children, is it, would you say it's advisable for people, depending on the age of your children, to put money into a trust with trustees to be released to them at, say, 23 and 30 years old, instead of giving them getting a lump sum and they may be 19 years old?
I think that there should be a trustee handling the funds. Could be a family member and a professional person.
Right.
And having a discretion to award them amounts for their upkeep, and for the spouse for that matter. Could be a discretionary trust where they have to maintain the family out of the funds that are available. And then the children could acquire a vested right to the amounts when they reach a certain age. Over 30, for example, or whatever it is.
Is it possible, and I know we're raising a lot of things here that people may not want to discuss, but is it possible for me, for example, to put in my will that the money that I leave to my daughter only goes to her? If, for example, she gets married to some guy who, and I'm not around to vet him and slap him a few times to make sure that he's the right person, and he goes on and gets divorced from her, and he then claims half of what I've given my daughter as part of his divorce. Do you know what I mean? Is there any way of excluding that possibility?
Yes, and that's normally put in a clause in the will as well, where you would then exclude it from any community of property accrual regime for the beneficiaries. And also from an insolvency point of view, you can then have that drafted into your will. And it's usually, I want to say, a standard clause almost as such.
Okay, now here's another one to throw into the mix. I pass away, okay? My will is read. Suddenly out of the woodwork, this child arrives who one evening when I had far too much to drink and got engaged in a manner with another lady, and this child is a result of that liaison. I'm not saying that is true, okay? This is not a admission of guilt. It's posing a question.
Yeah.
What happens in that case? Somebody waltzes in and says, I'm the eldest heir.
Depends on the terms of the will, how you've defined your heirs, I think.
So that person is not included as an heir because I didn't even know that he existed.
Correct, not automatically. So if you have to define your will, I leave my estate to my descendants, that child obviously on a paternity, proof of paternity, would then be included as a descendant. If you say I leave my will specifically to X, Y, or my estate specifically to X, Y, Z, that person then won't have
Okay, so that then comes to another point. You need to be absolutely specific.
In the will, yeah. The ID numbers and everything. Specific who the children, who the beneficiaries are, the heirs.
So you even need to go as far as ID numbers.
I think that would be preferable, yeah.
On the children one then, just with the nomination of, and we were discussing the trust, the other important one is if it's minor children, is the appointment of a guardian and a custodian. You can have two different people as a guardian and a custodian.
What's the difference between a guardian and a custodian?
A guardian is the person that if the child ends up in jail or needs an operation or you've got to sign any formal documents, the guardian is the person who's legally responsible for that child. A custodian is the person who the child would live to from day to day. So to give you an example, if you've got minor children, let's say before preschool, normally what happens is the children stay with the grandparents, but the grandparents might not be of an age to see the children to the age of 18 when they reach majority and they can then sign for themselves. So what you do then is the grandma and dad have got custody of the kids while they're little, but then you appoint a guardian who is young enough to see, God willing, the child to the age of 18, and they're then responsible for the child.
Jeepers, so we've just been talking for about 15 minutes about this, and already we've got a child born out of wedlock. We've got one of the children who's gone to jail.
It's like the Jerry Springer show.
It is, yeah. Jerry.
That's a normal South African family.
And then the other important one on the appointment of the guardians, make sure that mum and dad are appointing the same guardians, and also that the guardians know that they're guardians.
This is, to me, all that the two of you are saying is communicate.
Correct.
Communicate with your spouse and your family so that everyone knows where they stand. Because those must be very interesting meetings to be in when that envelope is opened and the executor starts reading out
Yeah.
I leave this to this one and this to this one. It must be fascinating sometimes to watch the faces.
Oh, completely. We've had to call the police into one instance where two brothers literally beat each other up because one thought he was receiving something and not the other. And it's actually very sad because it leaves a bad legacy or leaves a bad taste.
Yeah.
And mom then feels guilty because she doesn't, she wants to honor dad's intentions, but she doesn't want to, upset her sons. And it's nasty and it's horrible to do that. Clear it up beforehand.
This is a multicultural society that we live in. Any advice on the multicultural side of it?
Yes, you know what I'm finding in drafting a lot of black families' wills is that nowadays you don't really have the reading of the will as you had in Charles Dickens' times, but from a black family point of view, because the funeral is so important, they actually want a special family member or friend involved in the planning of the funeral.
Right.
So I'm finding now in my will drafting, we're actually putting those in to say that on my death, I want the following people involved in my funeral. I would like so-and-so to say something, because funerals in the black community are so important.
Let's come back to the money side of this now, because that's got me worried. Because now you're starting to bring up a whole lot of stuff that I didn't even know about. How, if assets are frozen, how are you gaining access to them to be able to pay those taxes and all the rest of them? I mean, how quickly do they come through?
Well, it's once the executor is appointed and you put in a tax return at the end of the tax year.
Okay.
There's first of all an assessment up to the date of death. And that would be put in due course, once all the figures had been got together. So there's no urgency to sort of realize that.
Okay, I suddenly had visions of
the receiver knocking on
yes,
your door
Yeah.
while you're sitting in mourning there.
Yes. Hello, Mr. Gordon.
No, they'd have to draw up the figures and do tax returns and things, which would take a few months.
Okay, so it's not these are not immediate payments that have to go out.
For instance, estate duty has to be paid within a year of death. So the executor then has got a year to start liquidating assets as such in order to settle the estate duty and any master's fees. And then from a tax point of view, again, as Michael said, you have it to the date of death. There's a deeming capital gains tax event. It's not as daunting in that if assets are going from one spouse to another spouse, there's rollover relief. So you might not necessarily have to write a check out. It will literally be assets that either go to somebody else other than the surviving spouse, or where assets are liquidated within the estate. And then you've got almost a year in which to settle that.
Okay, but then what about debtors? Do they have first bite of the cherry before it goes to spouse and children and all the rest of it?
Yeah, the creditors, the people that are owed money.
Yeah.
No, they'd have to settle the liabilities to work out the net estate.
Okay,
and that would then be
net
distributed
estate
in accordance with the will.
So in other words, when you're looking at the money that you're supposedly giving to your spouse or your children, you need to start looking at the net asset value of that, because there's a lot of that's going to be taken away by, I would imagine, the bank, the car, the financier, and any others who's standing in
the bond holder on the house, perhaps, people like that.
From a practical point of view, because we are sort of nearly out of time here. From a practical point of view, Michael, what would be the one thing that you would advise in getting your will together? And I know you looking more to estate planning, but from an estate planning point of view, what's the one thing that you would advise people to do because they don't think of it?
Well, to do an inventory of your assets, to keep an inventory of your assets, to see exactly what's there and how to deal with it, to consider forming a trust if you have a substantial estate, one where there's going to be growth in the future, and to provide for the family, and in the will to choose the right executor, as we've mentioned before the other day. The executor, the choice of an executor and the choice of trustees is very important, because there's the human relations, not just money and writing out checks.
And that's, I suppose, what we tend to forget about is the human element involved.
You don't want your executor to be like your bank manager. You want to go on your knees to ask for a bit of bread.
Yeah, exactly.
So I think the human aspect is very important.
Cheryl?
Mine would be to say, husband and wife do it together. As a couple, do it together. You know what? You're in there from a marriage point of view. Don't go on the basis that you think somebody's going to run off with the funds or they're going to marry somebody else. Do it as a couple. It solves a lot of heartache going down the line.